Hello, everyone. My name is Gabriela Barbosa. I am a board member of the ACS Los Angeles Lawyer Chapter. I'd like to welcome all of you who have joined us today for an overview and discussion of cases from the 2019-2020 U.S. Supreme Court term. Thank you to those who sponsored and helped plan this event, including the Mexican American Bar Association, the ACS Sacramento Lawyer Chapter Board, ACS National, as well as my fellow board members from ACS Los Angeles. A couple of logistical items. First, if you would like to receive CLE credit for attending today's event, please respond with your bar number to the confirmation email you should have received from ACS. You can also email ACS directly at lcemails@acslaw.org. That's L as in lawyer, C as in chapter, emails@acslaw.org. In addition, we will also have a Q&A section later on in the program. Please use the Q&A box in the Zoom to type in your questions. Now I'd like to introduce our wonderful moderator and panelists. Jennifer M. Chacón, today's moderator, is a professor of law at the UCLA School of Law. She's the author of an immigration law textbook and of numerous articles, chapters, and essays on immigration, criminal law, constitutional law, and citizenship issues. Jennifer clerked for the Honorable Sidney R. Thomas of the Ninth Circuit and holds a JD from Yale Law School and an AB in International Relations from Stanford University. Thank you, Professor Chacón, for being here with us today.
Thank you.
Next, I'd like to introduce panelist Aceli Martinez-Olguin. She is a supervising attorney at the National Immigration Law Center, otherwise known as NILC. At NILC, Araceli focuses on protecting immigrants' civil and workplace rights in the face of immigration enforcement and on defending the employment authorization and immigration relief available through the Deferred Action for Childhood Arrivals, the DACA program. Araceli also served as a law clerk to U.S. District Court Judge David Briones. She received her JD from the University of California, Berkeley Law School and earned her undergraduate degree from the Princeton School of Public and International Affairs. I'd also like to introduce Aaron Tang. Aaron is professor of law at the University of California Davis School of Law, where he teaches constitutional law, education law, and a Supreme Court seminar. Prior to joining the faculty, Professor Tang clerked for Justice Sonia Sotomayor at the Supreme Court and Judge J. Harvey Wilkinson at the Fourth Circuit Court of Appeals. Professor Tang writes about the Supreme Court in popular media publications such as the New York Times, The Atlantic, and Slate, and his scholarly work has appeared in journals such as the Stanford Law Review, California Law Review, and Columbia Law Review. Finally, we also have panelist Professor Kimberly West-Faulcon. She holds the endowed James P. Bradley Chair Professorship in Constitutional Law at Loyola Law School in Los Angeles, where she teaches constitutional law and advanced topics in constitutional law. A graduate of Yale Law School, Professor West-Faulcon clerked for the Honorable Stephen R. Reinhardt on the Ninth Circuit U.S. Court of Appeals. She obtained her undergraduate degree, Phi Beta Kappa, from Duke University, where she also graduated summa cum laude. Professor West-Faulcon's academic articles have been published in law journals across the nation, including the Journal of Constitutional Law, UCLA Law Review, and the Yale Law Journal. This is just a small window into the bios and the incredible work that this panel has engaged in, and I encourage you all to Google them and look them up to learn more about the work that they've done. Okay, Professor Chacón, can you please kick us off?
Sure. Thank you so much for the introductions, and also thank you for all of your work in getting us together here today. And I also want to thank ACS and the Mexican American Bar Association for sponsoring this event. I'm really looking forward to the conversation and looking forward especially to learning a lot from my fellow panelists. So I want to get the discussion started. I think we all know it's been a blockbuster year and a novel year at the Supreme Court. Adam Feldman reported on SCOTUS blog that there were only 53 signed opinions this term. This is the lowest number of signed opinions that the court has issued since the Civil War. There was unprecedented cancellations of arguments in March and in April. It's the first time since the Spanish flu in 1919 that we've had cancellations of these arguments. There were, for the first time ever, telephonic arguments in the late spring, and we could hear justices flush their toilets from home, making us all feel better about our own Zoom errors. There were arguments in May, there were July decisions. quite unusual number of them. So there was a lot that was new and novel. There were also a lot of really big issues on the table: immigration, abortion, anti-discrimination protection for LGBTQ employees, First Amendment religious liberties questions, presidential immunity, and treaty obligations of the United States to indigenous nations. There was one very significant case where the chief wasn't along for the ride, one that I hope we'll talk about a bit today, McGirt versus Oklahoma, in which the court, in an opinion by Justice Gorsuch, forthrightly acknowledged the treaty obligations of the United States to the Muscogee Creek Nation, and I hope we'll talk about that a bit. But for the most part, this was indisputably the Roberts Court. The chief was in the majority in almost every single case. And in some of those cases, the court didn't reach the predicted conservative conclusion, from the abortion case June Medical to cases concerning deferred action for childhood arrivals, the DACA program, the Regents decision, to cases concerning anti-discrimination protections for LGBTQ employees, Bostock and the consolidated cases there. But to observe that Roberts often provided the necessary fifth vote for these holdings is not to say that Roberts or the court has moved left. The court continues to move rightward, and the issues that they're being asked to decide are shaped on a legal terrain that is characterized by what has now been 50 years of a conservative court. Many of this term's cases are decided in ways that actually impose serious limits on the legal scope of individual rights protections and provide roadmaps for additional future limitations. As we'll discuss, this reality can be discerned in the DACA case and in the abortion case, both of which provide broad latitude for the government to act in rights restrictive ways in the future. The First Amendment cases articulate a shrinking establishment clause and a muscular free exercise clause, and therefore appear to pave the way for robust court protections for people asserting that they are discriminating under the auspices of their religion, even while preventing elected governments from denying funding to those discriminatory institutions. This will likely operate as a real limit on anti-discrimination protections for the LGBTQ community and on abortion and contraception access for women, notwithstanding Bostock and the June Medical decisions. There were also a lot of issues the court didn't decide, from Second Amendment cases to qualified immunity, and we'll want to pay attention to the meaning of those silences too. So I know our panelists have a lot to say about all of this, and I want to turn the floor over to our speakers. I've asked each of them to highlight one case that was of great significance to them for 5 to 6 minutes, and then after they've had a chance to talk about their case, I'll ask a round of follow-up questions to let them broaden the lens of their discussion. And after a few more rounds of follow-up questions where hopefully we'll be able to engage one another, I'll turn to audience questions. And as Gabriella explained in the introduction, you can put your questions in the Q&A feature of the Zoom room, and I will read them from there. So without further ado, I want to turn it over to Araceli to talk about the DHS versus UC Regents case.
Hi, everyone, and I want to pause and thank ACS and MABA for inviting me to join you all. Before I jump straight into the case, I think I can't get there without noting that the victory in that case was made possible really because of immigrant communities who themselves fought for and won DACA in the first place. And I like to start there because yes, like the creation of DACA is great and the court keeping it is great, but it's important to remember that immigrant communities fought for and got DACA in the first place, right? Those folks then mobilized across the country to unequivocally affirm that home is here for DACA recipients and their loved ones. And I also want to pause here in light of the administration's new memo yesterday, and their efforts to continue to chip away at DACA. So it feels like an important thing to note. All that said, all right, let's talk a little bit about the decision. Right, going straight from where Professor Chacón brought us, right, this was an opinion written by Chief Justice Roberts. And he was joined, in his opinion, he was joined by Ginsburg, Breyer, Sotomayor, and Kagan for almost the entirety of his opinion, right? There were two questions before the court as it relates to DACA. And the foundational one was simply whether the Trump administration's determination to terminate DACA was something that the courts could review. And then there is the second question of, assuming that courts can review whether the termination was in violation of the Administrative Procedures Act. Now, as you all know at this point, right, it is one of those cases that I think falls very nicely in the line of those where we had Roberts joining the majority for what seems the non-conservative decision. But one of the interesting things about this case, of course, is that the merit question before the court is ultimately just about the Administrative Procedures Act, right? So there's a way in which some of the principles that Roberts uses to keep the program in place are these fundamental principles about holding our government accountable for making reasoned decisions that both courts and the public should be able to examine and then reckon with the government for having made those decisions. So, right, what I'll note here is I'll pause for a moment to talk about the first question about justiciability. Right, the government essentially advanced two reasons for why no court should in any way be able to second guess the government's choices here. One related to whether this case is one of those rare ones that is committed to agency discretion by the Administrative Procedures Act itself, right? And ultimately, the court concludes that it is not one of those cases because ultimately this is not this is not simply a non-enforcement policy, right? DACA has two components to it, and by virtue of one opting not to enforce immigration laws or deprioritize folks from enforcement, that's only one aspect of it. Another important aspect of DACA is that it confers that attendant to it, once you are granted deferred action, you can apply for work authorization, you can become eligible for Social Security benefits, you can become eligible for Medicaid and state benefits as well, like driver's licenses. And so because there's this other piece to it, that's part also of the court's reasoning for why it is the administration cannot shield itself from court review when it chooses to do away with this program. I'll also note, just for anyone who is interested in the fact that, right, this is in some ways, this is ultimately about protecting folks from deportation and the benefits that come from that sort of deferred action. And so because we are in the immigration space, it should come as a surprise to no one that the administration tries to use these very large other provisions of the immigration law to try and say that the courts have been stripped of jurisdiction from hearing these cases. But the court also sort of pays this no mind and trudges on. One thing that's noteworthy, just to talk for a moment about the procedural history and sort of how we landed the court in the first place, is that, you know, this is a case where, much like the census case, you have decisions from the district courts that stop the government's actions, and so the government appeals to the courts of appeal, but instead gets us very quickly to the Supreme Court instead, right? Seeks cert before judgment. And I flag that only because this administration, I think it's worth noting that this administration very much likes to run to the Supreme Court when it can, and I'm glad that ultimately the DACA decision, along with the census case decisions, show that even when the court will grant cert, it's not simply just to rubber stamp the court's decision. One little piece here then about the merits question. So, you know, part of ultimately the question before the court is about whether the government has supplied sufficient reasoning for having terminated DACA. Usually when I have a little bit more time and I talk about this case, I go into the Dukes memo and the Nielsen memo and all the memo and the Sessions letter, right? The pieces that led us to DACA's termination. And I will simply note that, you know, what we have here is you had a letter from the Attorney General one day saying, we have concluded that DACA is likely unlawful and DHS should do away with it. The next day, there is a memo from the Secretary of the Department of Homeland Security essentially basing her reasons for doing away with all of DACA, or for the wind down that she does, in grounding it solely in Sessions' letter. There is another memo that comes later. I won't talk about that unless folks really want to hear about it, but the important piece there is ultimately that the court finds that this memo that gives everything short shrift, that has in some ways no reason for what it's done, is insufficient, which is something that I think, you know, I don't think you need the Supreme Court to tell you that the agency did not adequately consider what it was doing. Right? You have Jeff Sessions saying, hey, this is unlawful, and the Secretary for the Department of Homeland Security ultimately says, okay, well, he tells me it's unlawful, so I guess I better get rid of it. But what the court finds is that ultimately, and it finds that the government failed to adequately consider two pieces, right? We talked about the fact that DACA has two key components. One, which is forbearance of deportation, but importantly, the benefits that come along with work authorization and all the pieces that come from starting to order one's life, because you have both deferred prosecution, essentially deferred deportation proceedings, and all the ways in which you start to engage in work, undertake studies, build a family, buy a home. And so it finds that the court ultimately, that while Jeff Sessions, while the Attorney General's letter had decided that it was unlawful, that the benefits that were being granted were seemingly unlawful, it said nothing about the deferred prosecution, the forbearance from removal, and essentially said, DHS, you have failed. You had discretion here. You needed to consider why you would get rid of both pieces. The Attorney General's letter doesn't give you a single reason to get rid of forbearance from removal, and yet you've wiped away both. So, right, you haven't adequately considered the full program in basing your decision in the Attorney General's letter. And separately, even though we talk a little bit about, or I mentioned a little bit, the reliance interests that go into those two pieces, the court gives a second note there, bolstering the fact that the agency needs to grapple with all of the reliance interests, and all of, we had tremendous numbers. I think we had over 1,400 individuals and organizations sign amicus briefs for a total of, I think it was up nearly 40 amicus briefs, right, on our side, essentially talking about all of the contributions that DACA recipients have made to their communities, to the places where they work, to all of these things, and essentially the court itself also tells DHS that in order to do away with a program that so many folks depend and rely on, it needs to explain why it is choosing to do that, something that it had failed to do altogether. The last thing I'll leave you with regard to this case is that, one part that we don't talk about very much, and it got very short shrift in the briefs, and I think barely mentioned an oral argument, it was the equal protection claim that was also alleged by the plaintiffs. That's in part because at some point the questions presented looked like they would be, most of the action really was with regard to the Administrative Procedures Act claims, but in the opinion you have, and it's right, that's one piece of the opinion that's 8-1, right? Like, there's a piece of the opinion where Justice Roberts writes that ultimately the allegations that plaintiffs made about the racially biased statements made by the administration, the timing of the decision, all of these things, that they were insufficient, that there were insufficient allegations to plausibly to raise a plausible equal protection claim. And I want to note, I suppose, that it's 8-1, and I note it because ultimately you get this dissent from Sotomayor. None of the other liberal justices join her in it, but she does jump in to say, this isn't, first of all, she notes the procedural posture of these cases, right? Again, we're at the district court, it's a motion to dismiss. She believed that there was enough there to at least have the beginnings of an inkling of an equal protection claim, and she really sort of defends the idea that when you have these statements from an administration targeting a certain group of people, it should be enough to make out an equal protection claim. And I'll pause there.
Thank you so much. So I think we were now going to segue to Professor West-Faulcon to talk about Bostock and the other sort of related decisions dealing with the question of employment discrimination, anti-discrimination protections for LGBTQ employees.
Thank you so much. I would just like to start by saying I deem these cases to be some of the most momentous that we could have possibly had during this term, in the sense of prior to this ruling, there was no federal statutory protection with respect to discrimination on the basis of LGBTQ identity and status. And so before what I'm often prone to do, and I will take a few moments to do that, before I manage to pull some defeat from the jaws of this amazing civil rights victory, I do want to make sure I'm very clear and definitive about how hugely significant it is as a matter of doctrine, how hugely significant it is as a matter of its practical impact on the lives of individuals who have been excluded from civil rights protections at the federal level. So I think that's the big picture framing I want to offer as someone who teaches constitutional law. It's been a long-standing doctrinal takeaway that I've been trying to convey to my students, that far from what you might think based on your own intuition as a matter of the US Constitution and the Equal Protection Clause, there's no heightened scrutiny to government discrimination, government consciousness of one's sexual orientation or one's gender identity, and that translates to no civil rights protections with respect to the Equal Protection Clause. So as I've already started to move towards that, drawing the defeat out, so I'm going to try and keep a high note, but big picture as far as framing, this does not change the very narrow interpretation of equal protection with respect to protections on the basis of sexual orientation and gender identity. This is a momentous ruling with respect to the Supreme Court's interpretation of a federal civil rights statute, Title VII of the Civil Rights Act of 1964, a statute that's preeminent purpose is to prohibit employers, now amended, both public and private employers, from relying on characteristics of employees that shouldn't be relevant to employment decisions. So as part of that statutory delineation by Congress, Congress identified several specific ways an employer could behave, could act that would prohibit this federal statute. Among them were employers making decisions based on an employee's race, an employee's religion, and an employee's sex. And so where these three cases consolidated together, a case Bostock, Zarda, and EEOC versus Harris Funeral Homes came together, was that in each of those instances, the employees had been facially, explicitly subject to an adverse employment action based on their gender identity and their sexual orientation. And so while the employers were not challenging their behavior, they weren't challenging the fact that they had engaged in dismissal and adverse employment actions because of the employee's gender identity and because of the employee's sexual orientation, what the employers did challenge was whether or not it was appropriate to interpret the because of sex prohibition in Title VII to be applicable to adverse employment actions based on gender identity and sexual orientation. And so the momentous ruling is that we have a 6-3 decision by the current US Supreme Court, emphasizing current because we have strong, not just instincts, but we have a court that has an anti-civil rights record and several justices on the court that in their rulings, in their beyond just their substantive rulings, but our sense of their ideological commitments have already expressed anti-civil rights leanings. So how did we get a 6-3 ruling from the US Supreme Court that changed the lives of LGBTQ Americans in states that don't offer civil rights protections? It came in the form of a lead opinion, an opinion written by Justice Gorsuch, a dedicated and clearly and specifically aligned and self-described textualist who was faced with the terms because of sex. And the division that I would like to point to, and we can segue when we have our chance for questions and more dialogue amongst us later, is that the court could have taken multiple routes to this outcome. And the most direct route, in my opinion, would have been one that would have relied on very well-settled and long-standing Title VII precedent. Title VII precedent that is grounded in both the purpose of Title VII, which is to eliminate hierarchical and discriminatory exclusion of individuals based on protected characteristics, but also longstanding precedent that interpret Title VII in a way that was not particularly textual per se. Those of you familiar with Title VII know that it has been interpreted to prohibit sexual harassment, which is not textually delineated in the statute, that because of sex had been interpreted in prior cases and on multiple occasions to prohibit employers from both themselves engaging in direct sexual harassment and also prohibited employers from tolerating and failing to rectify a sexually harassing environment. So there was prior precedent that was settled precedent and decided by Justice Scalia that not only applied sexual harassment to women, but applied sexual harassment to male-on-male sexual harassment. And so the conclusion that because of sex was broad enough to cover sexual discrimination on the basis of sexual orientation and discrimination on the basis of gender identity was already baked in to the longstanding precedent. But a precedent-based approach to Title VII would have arguably been a broader interpretation because it would have been one where we'd read the majority opinion and we would have read an opinion that would have been focused on anti-discrimination. It would have been an opinion that would have been focused on how Congress's intent to make workplaces free and equitable with respect to access, irrespective of one's gender identity and sexual orientation, would have been very much in line with an anti-racist view of what Title VII is supposed to accomplish, an anti-misogynistic view of what Title VII is supposed to accomplish. Instead, the 6-3 opinion by Justice Gorsuch is one that moves the court in a direction that I would characterize as a very court-empowering direction, a direction where justices on the court are focused on particular words and subparts of statutes, and where a justice like Justice Gorsuch can not take much weight with respect to what Congress's original purposes were, but instead pulls out dictionaries, pulls out Justice Gorsuch and other justices' view of what a phrase like "because of sex" means, and then reach a conclusion that I think was one that was unavoidable with respect to the options that a self-described textualist like Justice Gorsuch had, and conclude that because of sex did in fact mean that when an employer takes into account one's gender identity and sexual orientation, that biological sex is inherently incorporated. So as we move forward, one of the things that I think we should be looking for from the court, and how I think this case fits with the broader conversations, is that despite it being, again, a momentous ruling, a ruling that it certainly expands civil rights in the realm of employment, it does not, in my view, necessarily mean that we have a court that is eager to protect LGBTQ rights outside of the context of this particular statute. And as we look at the court's other statutory decisions this term, again, the term that I come back to and the concept that I come back to is that overarchingly, I see a set of Supreme Court decisions that empower the justices in reading a statute in a way that may or may not align with the purposes of Congress, reading a statute in a way that may or may not align with prior precedent, and reading a statute in a way that does not necessarily dictate a similar protection of LGBTQ civil rights under the Equal Protection Clause, because the Equal Protection Clause lacks the term "because of sex." And I also see similarities with respect to what we might expect when the court moves forward in its constitutional cases, because it's also my assertion that this judge empowering approach to statutes is very similar to the court's judge empowered approach to interpreting provisions of the Constitution. That its approach to original meaning originalism and its approach to textualism are ultimately an approach to interpreting statutes and provisions of the Constitution in a way that gives the justices of the Supreme Court who have those approaches the opportunity to sit down at their own desks with their own old dictionaries or new dictionaries and ascribe meaning to the Constitution or statutes, again, without regard to the purposes of those statutes. So that's my my initial salvo and takeaway about these cases. And again, I hope I didn't present too much negative and because the last thing I'd want to do is downplay their immense doctrinal significance. But I do think for those who are signing on and wanting to think about what these cases mean with respect to a broader protection of LGBTQ rights outside of the context of this statute, or perhaps, as we will probably get to, how this bodes with respect to the court's foray into protecting very vigorously religious freedoms and the civil rights of folks who ascribe particular religious beliefs. I think there is sadly a pretty coherent narrative that I think we'll be able to weave as we move forward. So I'm looking forward to the rest of our conversation.
Thanks so much. That was great. And I'm now going to go ahead and turn it over to Aaron to talk to us about the president's financial records and related questions.
Thank you. So most of you probably already know the top line holdings from these two cases. I'm going to be talking about Mazars and Vance, the cases implicating the president's financial records, subpoenas seeking the president's financial records, right? So the president loses in Vance, which is to say the New York district attorney is allowed to subpoena his financial records from his bank and accounting firm. But the president wins in Mazars, at least to the extent that the House, which had issued the subpoenas at issue in that case, the House needs to go back to court, to the district court, to justify its requests for the president's financial records under a more rigorous standard, right? And these subpoenas are virtually identical in the New York case, the Vance case, and the Mazars case. So it's not the subpoenas themselves that are different. It's just the identity of who's doing the subpoenaing. In the New York case, the district attorney wanted the president's financial records to investigate potential violations of state law that members of the Trump organizations or the Trump organizations themselves may have committed. But in the House case, the Mazars case, various Democrat-led House committees sought the president's financial record for a number of legislative purposes. And so what I want to focus on in my time here is actually a broader question, which is what these cases and the actual reason that the court uses in them might suggest about the Supreme Court's approach to constitutional interpretation. Right? If you think about if there's any consensus right now about how the court approached various constitutional cases, its interpretive duties this term, it's that the cases were all over the map. Right? Jeffrey Rosen wrote recently in The Atlantic that the court's decisions this term lacked what he called, quote, methodological consistency or methodological purity, right? You know, you have some cases that Professor West-Faulcon referred to that are originalist or textualist in orientation, but there are a number of others that skip past history, original meaning, move straight on to precedent, a number that are really just focused on stare decisis, right? There's a hodgepodge of different interpretive approaches that we all studied in law school that were in play. And so there's this sense that, you know, there's no consistent one single approach to the court's big blockbuster cases this term. But I want to suggest that there actually is a common theme in a number of the court's decisions that's most easy to see in Vance and Mazars because the Chief Justice Roberts, who wrote these opinions, both majority opinions, made them explicit as the reason for the outcomes in both cases, right? So even though this isn't going to be a kind of formal theory of interpretation that you've heard of before, or at least maybe not one that you've heard of yet, it is what is guiding these decisions as well as at least the June medical case, and perhaps it's in the undercurrent in a few other cases, right? So what do I mean by that? So in these cases, the court isn't grounding its ruling, its decision in the Constitution's original meaning and precedent and interest balancing or, you know, other sort of common forms of argument you might expect. Instead, the court asked the following question: which side, if we rule against that side, will have the best chance to avoid the harms that that side would suffer from that defeat? In a bunch of these cases, the court is consciously identifying and then ruling against the side that does have good strategies, the best options for avoiding the harms that will result from its defeat. Okay, so that's kind of abstract. Let me try to unpack what I mean by this approach in Vance and Mazars. Okay, so in Vance, right, just to be clear, the court does not say that there's something in the original meaning of the Constitution or in precedent that requires the president to lose. It allows New York's district attorney to subpoena his financial records. The court actually declines to endorse Justice Thomas's originalist arguments in his solo dissent. The court actually expressly recognizes that there is no on-point precedent involving state criminal process, right? So it's not sort of a common law constitutionalist, living constitutionalist, or an originalist opinion. So what reason does the court actually give for ruling against the president? Well, it finds that the president has better options for avoiding the harms of a judicial defeat than would New York. Right? So start with the harms. The court says President Trump could suffer 3 kinds of harms. He uses the exact phrase: stigma, harassment, and diversion, if we allow state prosecutors to start subpoenaing him and future presidents. Right? He could be harassed, stigmatized from these subpoenas. But then the Supreme Court says, but look at all of the other ways he can avoid those harms if we allow this subpoena to go forward, right? So for one thing, the court says, grand jury secrecy laws. Why should we be worried about stigma to the president when every state that has grand jury proceedings would require the materials that are disclosed to be kept secret, right? There's no worry about stigma. Well, what about harassment and diversion? Well, the Supreme Court says the president has the same tools that every other person has to respond to particularly burdensome subpoena requests, right? If a subpoena is issued as part of a fishing expedition or in bad faith to harass the target of the subpoena, every state court has rules against those kinds of subpoenas, and the president can avail himself of those. And then the Supreme Court says the president even has a special tool in his arsenal. The president can bring a constitutional challenge, a supremacy clause challenge, arguing that this particular state court subpoena has subverted his ability to exercise his constitutional duties, right? The president's got all these options for avoiding stigma, diversion, harassment. But on the other side, the Supreme Court says New York has no good options if it loses, right? Right? It's trying to get all this evidence to uncover whether there have been violations of state criminal law. If it can't get this evidence, right, there's no way for New York to go ahead and prosecute law violators. The Supreme Court says there's one decent option we should consider, which is maybe we can retain all of the documents that are produced from the subpoena and then give it to the grand jury after President Trump leaves office, because then stigma, diversion, harassment, we're not worried about it anymore. But the Supreme Court says even that's not going to work, because leads are going to go cold in the interim, statutes of limitations are going to lapse, guilty people could go free, and innocent people might be prosecuted because maybe there's exculpatory evidence in the president's records that isn't disclosed as well. Right? So the court says President Trump has the better options for protecting his interests than New York, so the president wins in Vance. But now let's look at Mazars. This is the House case where the House committees are subpoenaing the same financial records, where the president wins. And the question is why? And again, the court doesn't find anything illuminating about Congress's power to subpoena the president in precedent or the Constitution's original meaning, other very common theories of interpretation. The court instead does the exact same thing it does in Vance. It asks, what can the House do to avoid its harm if we rule against it? And it compares that to what the president could do if we allow these subpoenas to go forward from the House committees. And here that question comes out the exact opposite way. And the reason is the House has said all along the harm it would suffer if it can't subpoena the president's private financial records is that it won't be able to legislate. But the majority opinion, Chief Justice Roberts' majority opinion says, not so fast, right? So I'll give one example. It's a little more complicated because there are 3 different committees issuing subpoenas. But one example is the House Financial Services Committee. Right, that committee said, we're subpoenaing the president's financial records and the records of his children and all affiliated businesses because we want to use them as a case study to investigate whether we need to change money laundering laws. right? Just general federal money laundering laws. We need a case study. We're going to use the president and we're going to subpoena him for this information. And the Supreme Court says, well, wait a second, right? If all you really are looking for is a case study, there are lots of rich people with complicated international monetary transactions that you could use as a case study. You need to subpoena them rather than subpoenaing a co-equal branch of the government and potentially burdening him or harassing them, right? And maybe for some panelists, right, it's hard to separate this particular president from that ruling, but we need to remember that this is a ruling that's going to apply to all presidents, right? So if there is at some point, for example, President Joe Biden, one might wonder whether we want, and for example, a House that's controlled by Republicans, House Republicans to be able to subpoena every last financial, medical, psychological, educational record belonging to a Democrat president either. And the Supreme Court says, right, if you can do the legislating you want to do without these records or in a more narrowly tailored way, you can do that. You ought to do that, right? The House has options. But on the other side of the case, right, the court says it's not clear that there's anything the president can do once he's subject to all these burdensome requests for private, like truly private educational medical records, if they could be case studies for any education law or medical law Congress is considering, not even passing, but considering, right? There's not going to be much of a way for the president to avoid that burden. Okay, so I don't want to go too much longer. I want to leave time for Q&A. I'll just make one last point, which is that this kind of nascent approach that the chief uses in these cases, and as I said, some others, might be good, or at least better than some of the other theories of constitutional interpretation that have gained traction out there. And we can talk if folks are interested about why that might be. So I'll give Elsie the floor.
Great, thank you so much. So what I'd like to do now is give everybody an opportunity to pull back the lens a little bit, maybe give some broader context to what the term looked like. We have some really important cases on the table now. Let's broaden out the view. And I'll go in the order that we went before, and I'm going to direct my questions to specific panelists, but I want to encourage other panelists to feel free to jump in at the end of their answers in order to share their own views. So I want to start with Araceli, and I want to kind of pick up right sort of where you ended. We had this sort of dispiriting equal protection discussion in the Regents case that gives us a clear sense that the court is going to continue to make it all but impossible for historically disadvantaged racial groups to make out successful equal protection claims. But obviously this wasn't the only case where issues of race and racism became apparent. And I wondered if you could talk a little bit more broadly about how we see the court and this term handling issues of race, including grappling with the history of racism in some of the other, starting with Regents, but also in some of the other cases as well. So I'll turn it over to you.
Thank you for that, Jenny. Or I should say, Professor Chacón. Part of the cases that I wanted to pull in were Ramos, which I don't know if y'all are, to the extent you all are not familiar with it. It's a case about non-unanimous jury verdicts being whether they're acceptable under the Sixth Amendment, and it's just a very telling opinion. The two cases I just want to pull in a little bit are Ramos and also Comcast, which is a case of interpreting or spelling out the theories of proof that are allowable to show racial discrimination under Section 1981. Ironically, it wasn't until I sat down to look at my notes that I realized both of them were Gorsuch opinions, which becomes important for this reason, right? So with Ramos, you have these two states, Louisiana and Oregon, who essentially adopt non-unanimous jury verdicts, I'm trying to find a polite way to say this, which is ironic because this is the whole point of my observation, right? These have just serious roots in white supremacy and in Jim Crow laws. And ironically, even though it's a Gorsuch opinion in Ramos, what you have is Gorsuch spelling out this history about how these laws were adopted. And to my mind, like the case itself, the decision itself is very much grounded, as many Gorsuch opinions are, since he's such a textualist. It's very much grounded in the text of the Sixth Amendment, or where the text doesn't give us very much because it doesn't say very much about the right to a jury trial. Sort of what the modern day, not modern day, but like the concurrent understanding, the understanding back when the Sixth Amendment was adopted, what it meant then, right? So that's what the decision is based there. But there's this very simple or glaring, the racial history behind these laws is so overt that Gorsuch, along with the folks who join him, right? Like that's where they jump from, which is just so interesting because then you see that in dissent, like look, the case, there's so much more to be said about the case to the extent folks want to talk about like what we're seeing from this court about precedent and when you abide by precedent and when it's all right to push it aside, because they did have to overrule because they did have to grapple with a previous opinion from the court that had previously allowed non-unanimous jury verdicts. So in the dissent, what you have are folks certainly on the one hand saying, hey, we have a precedent, and Oregon and Louisiana, you know, you shouldn't be wrapping them on the knuckles for having these laws in place, because you said back when that these laws were acceptable. But more notably, you have Alito, the Chief Justice, and Kagan also opening the dissent by scolding the majority for tarring both states with charges of racism and for having these laws in the first place. And it just felt very reminiscent. That exchange felt very reminiscent of the exchange that Sotomayor and the Chief Justice had back in Shute v. Coalition to Defend Affirmative Action, right? There's just this interesting way in which what I think we're seeing is that, you know, it has to be really blatant. I mean, I guess this is the other point, is that when you have, if you have, what we saw in the DACA case is the Chief Justice with 8 other justices all saying it isn't enough for the president to talk about Mexicans as rapists. It isn't enough for him to talk about just, you know, the inhumanness of migrants. Like none of that is enough. And also it isn't enough that and part of the reason it's not enough is because it's the president saying it and not the decision makers when it comes to DACA. Or like there's a way in which the majority opinion in DACA pushes away any evidence, all evidence that we put forward about the racial bias that is driving the president's decision and the government's decision to try to do away with DACA. Ramos gives a sense of, but look, even if it's this blatant, if it has to be this blatant for it to be important or matter. And yet I think it's worth noting that in the dissent, one, we get into this whole conversation about the fact that it's impolite, right? That it's impolite or somehow wrong to talk about race, right? And that brings us back to that exchange from many years ago between Sotomayor and Roberts, both in Shute and in Concerned Parents, about whether or not we should ever talk about race. So I think like the note I want to leave here is something like, you know, in the DACA decision, we're told that the president's statements about migrants are irrelevant. Ironically, what we see in Ramos is the same thing in the dissent, right? It's penned by Alito, but he's joined by the Chief Justice and by Kagan, where they say that the racist history of those laws is irrelevant because there's a good policy reason that the states can put forward for having adopted a non-unanimous jury verdict as sufficient for conviction, right? Because they're able to put forward some valid policy reason, the roots in racial discrimination become irrelevant, says the court, which then I'm just going to use to weave quickly into Comcast, because it's essentially the same holding there from the relevance of whether or not a decision has the relevance of racial bias in some decision becomes this thing where if there's with a court is, or at least Roberts, I feel, is making clear that if you can put forward, and this is where Comcast comes in, as long as you can put forward some valid reason for the action that you're taking, it becomes irrelevant and immaterial if there are also racist underpinnings for the reasons that you're taking. And that is explicit in Comcast, because there the question that was before the court is essentially whether or not under Section 1981, which guarantees everyone the same right to contract and sue and be parties as is enjoyed by white citizens, whether it was enough to show that, yes, Comcast chose not to contract with Byron Allen and they may have had some valid reasons, some non-racially biased reasons for doing it, but there are some serious allegations. But as long as you can put something out there, as long as there is some non-racially tinged reason, the court is willing to turn a blind eye to evidence of racial discrimination, which I think is just a very troubling thing to think about as as litigators or others think about the sorts of cases that you want to bring to this court.
Did any of the other panelists want to weigh in on this trilogy or reflections on race and this court, this term in general?
That was so well done. I don't want to retread any of that, but I would love to weigh in on the overarching point and how it fits into our broader discourse. And I'm going to try and see if I can successfully integrate one of the questions that I just noticed in the Q&A that was directed at me, which is a very good question, and I invited it by becoming a Debbie Downer very quickly in the presentation about such a momentous Title VII decision. But it'll be an opportunity for me to build on the questions about race and to also try to see and to take advantage of the historical moment that we're experiencing as a country. I've been telling certain individuals and students when I encounter them, there was many a decade where I defined the term structural racism. I never thought I would see it on poster boards and that people would be in the street and it would become a catchphrase of the time. So structural racism and its cousin structural misogyny, structural homophobia, structural, we can fill in those blanks, but it's long been true that the court's doctrinal black letter interpretation of the Constitution fails to make structural racism, structural misogyny, and explicit facial discrimination on the basis of gender identity, sexual orientation, etc., as well as we haven't even progressed to a more sophisticated way of discriminating against people who fall into those categories. But the point is, with respect to the meaning of the Constitution, that has been one of the conclusions once you learn about constitutional law. Hey, we don't have very many tools in our toolbox if you want to go to court and try to rectify those kinds of wrongs. So the point I'd like to make with respect to building on where that fits us with respect to race is that certainly hasn't changed this term, and everything that happened this term reinforced the fact that in, again, trying to use catchphrases and terminology that I never thought would be common for people in the United States. That shows you, again, what a cynic I am, but anti-racism. I was like, wow, that's a phrase now. So we do not have an anti-racist U.S. Supreme Court. You know, spoiler alert, right? That has not been the way they've interpreted either the Constitution itself, and going back to my observations about Title VII, that there are ways to interpret Congress's statute in Title VII that would be the actual purpose would be to not just prohibit an employer from engaging in facial, explicit, I did not hire you because you're Black, I fired you because you're a woman, I didn't hire you because you're gay, but that Title VII's purpose, as interpreted and as confirmed through various Title VII rulings. So I would say this is bread and butter, black letter doctrine, right in the center of the understanding and meaning of Title VII, and its purpose would be to dismantle structural discrimination. And so what I'm saying about the road that Justice Gorsuch went down is that it is, from the outcome, an absolutely progressive vote. A vote in favor of the plaintiffs in those three cases, including Bostock, is definitely a progressive vote to the extent that progressivism is pro-civil rights, pro-inclusion. It is opposition to taking an attribute of a person that has nothing to do with your ability to do your job well, and then using that against them to fire them. But if we take a Justice Breyer approach, a purposive approach to what is the statute's purpose. Now, I'm not speaking of its specific intent. Now, one thing I would say is a through line about how these justices interpret both statutes and the Constitution is they don't give a hill of beans about the specific intent of the people who wrote the words. Now, that's the sort of distinction that a con law professor would love to delve into for a very long time and can get very boring for the rest of folks. But I point that out to say that this is also a court that is not constrained. I think what is ominous about this court is that, and I was looking, Aaron was trying to come up with an overarching descriptor. I'm going with court empowered, and I'll say that I was quite grateful the court was empowered enough to get the basics of, separation of powers one-on-one, and held that Donald Trump is not a king, even though he wants to be one and he doesn't understand Article 2. So I'm glad the court was sufficiently empowered to deem that a justiciable question, and they ruled. But there's also an empowerment of a court that purports to be constrained by text, because a lot of lay people go, if you have originalism or textualism in any version of what you say you do, I'm going to assume you're constrained. And so I think this is a set of justices who have been very savvy in how they've labeled their approach to interpreting statutes in the Constitution. And they don't get complete credit, right? This has been going on for decades, but very savvy in giving labels that would let lay people think that it is the text of the statute or the text of the Constitution or the intent of the framers of the Constitution or the intent of those who wrote the words that is some kind of constraint on them, the justices of the court. Because we all like to have some confidence, because we don't know who's going to be on the court, and the people on the court can oppress us not quite as readily, but pretty darn well if there are no constraints on them. So what I am trying to point out about Bostock is that it would be more constraining of Justice Gorsuch if he embraced that the purpose of Title VII is anti-subordination, that the purpose of Title VII is to free employees from being discriminated against based on job irrelevant criteria. And there is tons of Title VII precedent with just that kind of terminology. Instead, we get a lovely textualist, detailed, again, pull out the dictionaries, let's dive deeply into the words. And when it comes to something like the Affordable Care Act or another statute, the Religious Freedom Restoration Act, or wherever the Supreme Court goes next, what we have, and these justices are rightly criticized for it in my view, a judge-empowered court that can take their dictionaries and go virtually anywhere they want to go. And big picture, what we should see when they're interpreting statutes is a court that is constrained by whatever Congress's purposes are. Where this gets a little mucky when it's Title VII is that the purposes of the Congress that passed Title VII was a Congress that was focused on racial justice, was a Congress that had the word sex inserted by an opponent of Title VII who was racist in his intent. It was not an anti-racist inclusion of sex as a criterion. It was an inclusion of sex to hopefully get members of Congress to vote against Title VII. So I would say that would explain why looking at the purpose of a statute could indeed be much more valuable than diving deeply and attempting to discern what those who wrote the words meant the statute to mean. But with respect to Title VII, there could not be a clearer purpose. And if this had been an opinion that focused on that anti-subordination, that anti-hierarchy, that anti-job irrelevant criteria meaning of Title VII, it would be a bigger opening to, well, what does the Equal Protection Clause mean? What does this mean for Title IX? What does this mean? Because we have that invitation headed for the court as well, that to the extent that transgender identity protections are part of what the term sex in a different federal statute means, Title IX, we have a series of lawyers and people with a particular agenda who are set on creating a collision course between their assertions of religious rights and religious freedoms and any civil rights protections that are conferred to people on the basis of their gender identity and their sexual orientation. So with this only focus on the word and the text and no focus on an anti-subordination, anti-discrimination, pro-inclusion interpretation, it gives the court free rein when it comes to what do we do when these purportedly conflicting principles clash. And this is where I'll go back to race. The absolute, and I'm just gonna, I've been saying that I'm being very descriptive and not necessarily free, but very frank, because I am ultimately in my home, right? So why can't I speak freely if I'm in my home? So to be frank, I find it very perverse, absolutely perverse, that the religious freedom cases are full of terms that we associate first and foremost with race discrimination. That we have justices who have, exactly as Araceli just described, a kind of tisk, 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 how dare you bring up racism? Now, and then who knew that this would be in the midst of the entire country deciding, oh, we're gonna have a big old conversation, not about just race, but we're gonna dismantle structural racism, which again, just blows my mind. Where we'll go is a whole nother question. But the religion cases, and it's not just this, it started with Trinity Lutheran, are filled with the terms like bigot. Bigot? I am writing in the margins like, are you kidding me? Because George Floyd can be murdered and it does not raise heightened scrutiny under the Equal Protection Clause. Unless we could get somebody on the record to say that the policy adopted for the knee in the neck was purposely adopted because of its negative impacts on the basis of race, not in spite of, an extremely high evidentiary bar, an outrageous evidentiary bar, an evidentiary bar that makes it impossible to ever litigate and challenge structural racism. But in a realm where we used to be pretty agreed that we had reached a balance between the separation of church and state that was appropriate, where we could protect free exercise, but yet not have an established state religion, you have the justices of the Supreme Court providing cartoons that are supposed to convince us that despite no evidence of a facial or even structural intent to purposely discriminate against Catholics or purposely discriminate against Christians, that somehow the religion cases are all about bigotry and discrimination, and they use the term repeatedly. And so that's where the perversity comes into play, is that there is a series of cases now that if you are a tried and true, and I'm from the Bible Belt, I will also give my own personal biography, so no one perceives my my critique of this as perverse as anti-religion. So I'd say, as an African American from the Bible Belt who grew up in a Black Baptist church, I can still disentangle the idea that I have free exercise from the idea that there is discrimination against Christians. And so we have a series of cases in that realm that have lifted up this notion that those who are the greatest victims of discrimination and bigotry in 2020 in the United States of America are Christians. But people of color, not so much. So I'll stop there. But that's what comes to mind, that I think when you back away from it, it really is. It's not this progressive term. Instead, it's a term where a lot of things are happening very much under the surface, and it makes sense for that to be led by an institutionalist, and people call him an incrementalist. I don't know if Justice Roberts is as much an incrementalist as he is a savvy, he's very savvy in recognizing how he can move the court in the direction he wants to move it without getting too much pushback from either the political branches or us, the people reading the opinion. I think you have to have an extremely high level of knowledge about almost every one of these cases to see what's going on under the surface.
Thanks so much. So Erin, I want to give you a chance to weigh in on the race and religion cases that we've now sort of opened them all up and connected them. And also I'm hoping you can talk a little bit about cases that weren't decided, or where some of the silences are, which I think also maybe don't get as much attention, but also help to give us a sense of what it is that this court cares about, what's important to the overall agenda, and where kind of decision not to intervene is also a significant one.
Sure, thank you. So I don't know that there's much I can possibly add to the incredibly enlightening comments that Araceli and Professor West-Faulcon made about the relationship between race and religion. So I'll focus on sort of the second part of the question you asked, which is what didn't the court do that might matter just as much for the rest of us as what the court actually did do? Right? We tend to spend a lot of time in these end of term reviews thinking about, you know, the merits decisions, the 53 or however many signed opinions that the court delivered in fully briefed and fully argued cases. But I think that there were two particular choices the Supreme Court made not to decide big issues at the very end of the term that are arguably just as important in terms of real life consequences for the American people, right? So so I'll start with police brutality. So as Professor West-Faulcon alluded to, right, we are an incredible moment in American history where we're finally having open conversations about what it might mean to hold police accountable for, you know, an incredibly painful history of brutal actions to innocent civilians, as manifested in the killing of George Floyd and countless others, obviously. And to the point where, you know, federal courts nerds were just incredible that American people were up in arms over this doctrine of qualified immunity. Right? So if you've followed this discussion, qualified immunity is the Supreme Court's special defense, a judge-made defense the Supreme Court has announced over the course of the past 40 or 50 years as a statutory interpretation, an interpretation of Section 1983, which allows people to sue for constitutional violations, to sue government officers, in particular police officers, for constitutional violations. And the Supreme Court has basically given police officers and other state actors this qualified immunity defense that says you can't get sued and you can't be held accountable to pay money damages if you're a police officer unless you knowingly violated a clearly established constitutional right of which a reasonable person would know. And that's such a hard standard, as many of you probably know, to satisfy, that most of these, you know, even these worst police brutality cases just get kicked out before we even get to summary judgment or even trial. So remarkably, we have 5 votes. It's pretty clear we have 5 votes in the Supreme Court to overturn that doctrine, pare it back, make it much easier to sue officers who violate constitutional rights. The 4 liberal justices have all expressed reservations in a number of cases about the court's qualified immunity doctrine. And Justice Clarence Thomas has written multiple separate opinions now saying, listen, the court just departed from the original understanding of Section 1983 as it was enacted after the Civil War. We should revisit and pare back this ruling. And so there were 10 cert petitions that the Supreme Court was considering in the final weeks of the term to grant, in which they could have granted review and taken up the issue and revised qualified immunity doctrine to make it what sort of uniformly conservative and liberal academics have argued to fix it, because it's broken right now. A sort of bipartisan agreement that the Supreme Court's qualified immunity doctrine is wrong as a matter of statutory interpretation. And yet the Supreme Court denied cert in all of these cases, even though we're in the middle of this national conversation about police brutality. And so one question is why? And I think here, this is sort of like one of those impossible trade-offs that if you put yourself in the shoes of a liberal justice, an impossible trade-off that you have to make. Right? Because in order to fix qualified immunity, if you vote to grant cert and join Clarence Thomas in an opinion making it easier to sue police officers, right, you have to undo dozens of Supreme Court opinions. You have to explain why, as a matter of stare decisis, those decisions are now wrong. Why you, to talk about Professor West-Faulcon, her court empowerment terminology, why you, the current Supreme Court justices, suddenly know better than every single other Supreme Court justice who has reached the opposite conclusion before you, right? It's not an easy thing to do, especially when the court's settled rule is, in statutory interpretation cases, stare decisis has special force. Why? Because Congress can just fix an incorrect Supreme Court ruling, which, you know, as many people can agree, qualified immunity is incorrect statutory interpretation. But it's very hard to look at, even as you're arguing that we should, you know, undo 50 years worth of precedent, it's very hard to look Chief Justice Roberts in the eye as he's just joined an opinion in June Medical saying, for stare decisis purposes, I'm willing to respect whole women's health versus Hellerstadt, a constitutional opinions where stare decisis is at its lowest ebb because Congress can't fix an incorrect ruling, right? The liberals have just convinced Chief Justice Roberts to abide by stare decisis in that case with respect to abortion. It's very hard to do that and say, but oh, in the meantime, we're going to go and rewrite all these precedents we don't like. You have to stick with the precedents you don't like. So I think that explains why, notwithstanding the clear need and votes to fix qualified immunity doctrine, that case wasn't decided. The last case I want to talk about, because folks might be interested, or a set of cases, has to do with gun control. The Supreme Court had heard oral argument in a case called New York State Rifle and Pistol Association versus City of New York about a very strange or kind of one-off New York law that was one of a kind, an outlier that was particularly restrictive of gun rights. The court didn't end up deciding that case, didn't issue any new law, dismissed the case as moot in a opinion joined by not just Chief Justice Roberts, but also Justice Kavanaugh. And if you'd asked me back in, I think, March or April when that opinion was written, whether that was the end of the Supreme Court's Second Amendment conversation, I would have said no chance. I guarantee you that the Supreme Court is going to grant cert in a slew. Again, there were something like 8 or 9 cert petitions where people, gun rights activists, people who want more guns in the public space, want to be able to carry their guns wherever they'd like to go, had challenged state restrictions on that rule. And the rubber hits the road at the following kind of law, right? In Washington, D.C., 8 other states, mostly blue states on the coast, in order to be able to carry a gun in public, you have to be able to show to the police that you have a particular need for a gun in public, right? If the idea is self-defense, well, you need to be able to show, well, I am in fear of self-defense. I have good cause. Maybe there's a restraining order out against somebody. I'm in a particularly dangerous profession, right? There's some reason for me to be able to carry a gun in public. If you like the idea of walking around and people just generally not having guns wherever you are on the street, those are the kinds of laws that you might support. And there's empirical evidence from John Donahue at Stanford that these kinds of laws, these limits on who can carry guns in public, reduce violent crime by anywhere from 13 to 15%, right? So they're not just, they're efficacious laws as well. There's a circuit split on that, on whether those laws are constitutional, whether they violate the Second Amendment right to keep and bear arms. The District of Columbia struck down a DC ban saying those laws violate the Second Amendment, but 4 other circuits, including the Ninth Circuit, have said no, that these kinds of laws are permissible. Multiple cert petitions presenting this question. Justice Kavanaugh said these are the kinds of cases we should hear in his concurring opinion, dismissing the New York case as moot. And yet, in the last week of the term, the Supreme Court denied cert in these cases too. Joan Biskupic just reported, I don't know who her source is, but she just reported on Monday that the reason cert was denied in these cases is the 4 non-Chief Justice conservatives were worried he was going to get squishy on the merits of this case. And so perhaps that explains why there was a vote to deny, although that would have also been true of the New York case that they voted to grant last term. So I'm not sure, maybe something's actually changed about the Chief's views. But that's a pretty remarkable thing, given the conversation and the stakes of gun violence, for the court essentially to say we're going to leave these 8 states' laws in place and not take up this case has pretty drastic implications for, I think, for the American people.
Thanks so much. And your answer was great also because it touched on precedent and abortion, both of which I think are themes running through some of the cases. It called to mind for me Araceli's remark about Justice Kagan joining the dissent in Ramos, which we can read as sort of aligning herself with sort of a dubious desire not to talk about race, but we can also see that as a pro-precedent move, right? One that's saying stare decisis matters and we've decided this issue before, something that I think was, as you said, an important concept in the June medical decision. So we have about, it looks like 12 minutes left, and we have some questions from the audience. And if other audience members have questions, please feel free to put them in the chat. I wanted to just sort of group a couple of them. And so one question that came was about leaks and what we can make of what's happening. And this just flows directly out of something Erin was just talking about. So if people want to comment on that, you are welcome to do so. The other question that I wanted to highlight, though, is someone brought up the travel ban. It's been obviously 2 years since the court upheld the travel ban. I find that question really interesting in the context of the discussion we've been having about when discrimination is acknowledged and what kind of religious discrimination is acknowledged and under what circumstances. circumstances. I think that has interesting connections with some of the earlier remarks. So it might be interesting for people to talk about sort of where we stand there, if you want to react to either of those questions.
I'll talk about, sorry, go ahead, Professor West-Faulcon.
Oh, okay. Well, I'll try to keep it brief.
And it looks like all three of you want to weigh in, so we'll try to stick it to 2 minutes each so everyone gets a chance.
Okay, so I also love that I got a question in the chat about my view of the term racism or anti-racism. And I'd love the opportunity to be clear that as a matter of constitutional law, I never touch that term doctrinally. I don't think anything in the US Supreme Court's jurisprudence in its modern cases attempts to capture that. And that is the only point that I am trying to make, that big picture, what the court accomplishes is it puts certain limits on government power. Whether that's the limit on the government's power to regulate a firearm, a limit on the government's power to regulate an abortion pre-viability, whether that is a limit on a government, or in the case of a statute, a private actor's power or ability to fire someone based on their sexual orientation or prohibit them from marrying. And so big picture, if you back all the way away and look at when the court deems it important to intervene, when the court deems it important to put some limits on what the government can do to other people, that's where I can bring in the answer about the travel ban. That if we look at these cases in the context and in the broader context of what it says about when the court will apply some degree of scrutiny, when it will scrutinize the action, or when it will just let the government treat us as the individuals or regulate us or decide who can come and leave the country, that's where the perversity slash, if I weren't taking the very frank route, I would take a more legalese route and say where the inconsistency comes into the play, where there's an inconsistency in how the court uses its theories of both constitutional interpretation and statutory interpretation. And there's a lack of consistency in how it interprets limits on executive power. With respect to the travel ban, there's no question that a president has the power to decide which countries people can enter from. That's the power question. And so the issue, though, with challenging President Trump's quote unquote, we're going to call it travel ban, was that it would have on a con law exam been a violation of the Equal Protection Clause, because we would have written into the exam a president that before issuing this ruling about this executive order as to who could enter and leave the country, said extremely explicit, this is going to be a Muslim ban. So not only a violation of the Equal Protection Clause, but a violation of the First Amendment, because it is targeting individuals based on their religion and probably intersecting based on their national origin, but certainly very explicit. And so the fact that the Supreme Court that had told us beforehand that in cases like Washington versus Davis and Personal Administrator versus Feeney, that again, as I mentioned it before, if you can prove that the government took this action because of that desire to exclude based on a particular characteristic, that was going to be the holy grail of getting over this impossible burden of evidence. Now, the reality is, as I said, most things that happen in polite conversation nowadays, where people don't say the quiet things out loud, was that most civil rights lawyers would tell you, so that means most things aren't actionable. There's no scrutiny from the Supreme Court. The fact that the travel ban was the quintessential fact pattern that you would have put on the con law exam to say, well, no one would ever do that. Like, we're never going to have a president that would say the quiet things out loud. They would just use their power discreetly and never say we're doing it because people are Muslim. And so where it really gets to, again, me trying to make a sense of how it all fits together, if we were back in the world that would have been a world when I was, and then let me wrap up because I realize I'm going over, before I was in law school, they told us that the court cared about intervening and being scrutinizing when those being impacted were a discrete and insular minority, a numerical minority, the groups that could not use the political process to protect themselves, and that the court cared about the political process. So I'm going to get another one in, Jennifer, that they aren't deciding the voting rights cases, right? They're just letting the political process perhaps be twisted, and we the people may not get our say. They're not, Justice Roberts oversaw an impeachment hearing where the allegation is that there is foreign interference in our elections and the court isn't jumping in there. But where are they jumping in? They're jumping in to help religious groups that aren't minorities. That's the other piece of this. That's why my emphasis was on the civil rights of Christians, or the religious rights of Christians. It's not the religious rights of religious minorities writ large. And I see that this is a court that is creating a collision between certain rights that they think are worth protecting, and I think the Second Amendment right is a quintessential example. And I think we're now, with respect to the reproductive rights, at a point where the court is almost applying a version of rational basis review to something it has made is a fundamental right in name only. So that's where I see the connection being, that this is a court that only gets involved and when it seems that it is a group that could otherwise use the political process to protect itself, and it's not stepping in that historical way. A lot of our, maybe people a couple of generations before us were taught in law school was what was the real role of the court.
Thank you. And I think you took this kind of broader and gave a big picture sense of where you see the court in this in this kind of broad set of issues. And so I want to invite the remaining two panelists to comment similarly, so you can answer the specific questions that we have on the table from the Q&A queue, but also feel free to sort of take that up a little bit broader in the remaining minutes that we have. So Araceli, did you want to step in?
I have a short through line, because I think in this way where I see the travel ban case fitting is and I love the way in which the professor is sort of talking about this as a law school exam question, because I think the thing that's tricky and fun about this one is that ultimately it brings us back to when Roberts in particular, but this court more generally, finds that evidence of bias, be it right, anti-Muslim or racial discrimination, where they find it relevant. Because remember that part of the way that they justify the outcome in the Muslim ban, and then this also weaves through for me to the census case and to DACA, to the Regents decision, is that you get, they allow the travel ban because while the president said all of these horrible, clearly biased things, by the time it gets to the Supreme Court, we're at Muslim ban 3.0. They have given all these extra decisions, they've given all these extra justifications. We have added these countries and not that country, and look, we've cleaned it up. We dotted our I's and crossed our T's, and we have managed to comb Donald Trump's hair and make him look presentable, right? There's this way in which what they're saying is we're back to that little undercurrent of the Ramos dissent, where the Ramos dissent, where they're saying if there is some viable policy reason for this, the racial bias behind it, no matter how evident it might be, is irrelevant. Right, and that's the census, in some ways, like the census case and DACA too. It's like you have to give us a real reason here. It's not that you can't do what you want to do. You just have to be real with us about it. But let's be clear. Keep this polite. Don't talk to us. Don't talk about racism. Don't talk about these things. And ironically, I think maybe this isn't where where Alan wants to go, but I actually really like your overarching your interpretation piece of which side has good strategies for resolving the harm, because in that way I'm that feels true for the DACA case as well. Just that last note of, look, we're going to let 700,000 people stay in the United States, keep their forbearance from deportation and their work authorization, and keep their lives stable, because the government can go around another way to do this if they want to, right? I love that piece, and I'll cede the floor there.
Great, thanks, Erin.
Perfect. Yeah, I think that's another great example of the case. So I'll just sort of wrap up by talking about the two biggest cases next term and what we might expect there, because I think they shed some light on some other themes that were picked up. There's two big cases next term. One case involves the Affordable Care Act, Obamacare. Is it gonna be struck down in its entirety because for some odd reason, 3 years ago, the Republican Congress zeroed out the tax penalty that you would have to pay if you didn't carry health insurance and just said, if you don't carry health insurance, you pay $0. Texas and some other states now say the entire Affordable Care Act has to be struck down because of that one tiny change. The conservatives are going to lose that argument. I can promise you they're going to lose. The only question is it going to be 7-2, 8-1? The writing is on the wall. So the Chief and Justice Alito and Kavanaugh have actually both signed on to pretty good severability opinions that's going to keep the Affordable Care Act safe. The only question is what the vote's going to be. The conservatives are going to win in the other big case. The other big case involves foster care and adoption, and whether faith-based adoption agencies have to make their services available to same-sex couples. Right? So in the city of Philadelphia, there was a particular agency, a faith-based agency that did not want to provide its services to same-sex couples. The city of Philadelphia said, well, then we're not going to pay you money, right? They're a contractor. The city is paying money to private agencies to help assist in the foster care and the adoption process. We're not going to pay you money if you're going to discriminate against same-sex couples. And to Professor West-Faulcon's point, the faith-based agencies, religious agencies, Christian services are now suing, saying this violates the free exercise clause. They're going to win that case. It's going to be a 5-4 opinion. They're going to win. The only question is how bad, sorry, that's pretty frank. The only question is how far the court is going to go to support the religious position, right? One option is to say, just this particular case, what Philadelphia did in this particular case looks bad. It looks particularly discriminatory. But the other option is to rewrite the free exercise clause altogether and say that basically anytime religious organizations don't like a general law, generally applicable law that they don't like, they get an exception. There is some possibility that would happen. Based on this past term, I don't think Chief Justice Roberts is going to go all that way. I think he's going to rule in favor of the religious freedom position and a narrower opinion. But those are, if we're thinking about what's coming up ahead, those are two big cases.
Great, thank you so much for giving us a little bit of a preview in addition to our look back. I see we're at time. There was one other question that I just wanted to highlight, and it was, how can the average person that didn't go to law school stay up to date with accurate information on constitutional law cases? And my favorite source is podcasts. I love the Strict Scrutiny podcast, which is one way, but there are others. And so one thing that I might suggest is when ACS posts the recording of this video, that they might also see if they want to include some additional resources that might be available to people who just want to stay abreast of developments on the court. Because I think, as this discussion suggests, it's sort of a central component of our democratic system in these discussions, and having people involved in these discussions is such an important part of participating in a functioning democracy. So thanks again to ACS and to MABA for pulling this together, and to all of you for sticking with us, for asking great questions, some of which we unfortunately didn't get time to address. And then there's a technical question about how you get your MCLE credit. So I will turn it over to somebody who has that information, and just thank our panelists for being here from their homes, being frank with us, and thank you for your insights and your wisdom. I have learned a lot today and appreciate all that you've done to get ready for this.
Thank you all to our panelists and our moderator. Really quickly, I can answer the question about CLE credit. If you would like to receive CLE credit, you can respond to the confirmation email you should have received about attending this event from ACS. You can also email directly this email. It's lcemails@acslaw.org. That's L as in lawyer, C as in chapter, emails@acslaw.org. Thanks again to everybody, and that's the end of our program. Bye, everyone.